Good afternoon, everyone. I, Ankit, on behalf of NEN and Vadvani Foundation, would like to invite you all for this webinar and also introduce our expert, Mr. Praveer Gupta, founder and CEO of RippleIP Services, a mechanical engineer from IIT Delhi. Praveer brings nearly 10 years of extensive IP, technology strategy, and innovation experience. As a lead of Office of Technology Strategy and Innovation at Sanofi, he was responsible for providing strategic inputs on various cutting-edge technology deals and reported to the CEO on overall strategy. At GE Corporate R&D Center at Bangalore, he received US Patent Agent equivalent training and certification, Six Sigma's Green Belt training, and worked with several patent attorneys on preparation and prosecution activities across several GE technologies. As advanced patent agent, he trained and mentored several patent agents and served as IP consultant to GE Consumer and Industrial Lab. At Patent Metrics, he was responsible for developing IP-based investment report methodology and patent applications of several cutting-edge technologies. Before I hand over the floor to Praveer, a quick note to all our attendees. You will all be on mute. You may ask questions by typing in the panel provided. Our expert will answer the questions after his presentation. Over to you, Praveer.
Thanks, Ankit. So, good afternoon, everyone. And I'll be speaking on basics of intellectual property and uses in businesses. And as Ankit mentioned, that I've been in this field for around 10 to 11 years, and I've seen India grow in terms of IP pretty extensively. But I think I got this feedback from everyone that since the Apple versus Samsung case was decided, a lot of you joined in as attendees for this webinar. So what we will do is I will go through the basics of IP and intellectual property. But towards the end, if we have time and everybody is interested, we will go through one of the web articles that I have together, and I will give you a summary of that case since you're interested. And I apologize I didn't have enough time to include a slide on that, but I think the web page will serve just fine. Also, this webinar is designed to be interactive, so please feel free to send me questions, and I will be able to answer those as we as we're going on. All right, so. Okay, so let's start. And so every one of you has heard about Apple, but have you heard of these four? Most likely, I don't expect you to know, but if you heard about Vonage, Vonage is one of the leaders in voice over IP devices. They have an excellent suite of products that they make, and you can use them as regular phones in your homes. And they were the first to market, but they did not do any of the IP work that's required to be done. And very soon, while they had the market-leading product, they were hit by patent lawsuits, infringement lawsuits, and they lost a lot of money. I mean, $200 million might seem small in front of $1 billion, but it's not small money; it's huge. They lost over 4 or 5 years. But the bigger thing was that the leadership was focusing on these things rather than focusing on growing the business. But they were focusing on the lawsuits. And therefore, I think the actual loss to Vonage was pretty high. Similar issues with BlackBerry. You can see that despite this kind of a loss of $650 million, they still did very well for their business. And ultimately, the favor with the White House supported them, and for that reason they still are in existence. But they really lost a lot of money because of their inaction in IP. They should have taken right action. Look on the other side of the coin, and you will find companies like IBM, which start filing patents on a lot of automation related technologies, and today they get a licensing revenue of about $1 billion annually. That means that there's a person sitting there just collecting checks for pieces of paper. Similarly, if you probably have heard about the acquisition of Motorola by Google. Do you really think Motorola had that kind of a product that Google wanted to buy? And I don't think they did. I think they were primarily bought for their patent portfolio which related to these devices, and the amount was staggering, 12.5 billion. So all of this is really a game of intellectual property. And while these examples are from a developed economy scenario, we are not very far off. We have already started seeing signs of that in India, and intellectual property will become a way of doing business more than being a cost as it is perceived today. So let me tell you a bit more about it now. So if you have not heard about what is this thing, let me first underscore that this is property. As you saw in the previous slide, there is a lot of money involved that exchanges hands, that can be generated. So clearly this is a property, but the difference is it's intellectual. And what it means is that it's a product of your intellect, or something that is not physical, but rather an idea. And that's what this property relates to. Now there are various forms of ideas, or various forms of ideas that are valuable as property. And for that reason, there are correspondingly different kind of intellectual property rights. And these rights are protect the biggest four rights that are known are patents, which protect something that is innovative or technical. So it essentially is the invention that is protected by patents. And the requirement for having a patentable invention is that it should be novel, it should be new, and it should not be obvious to somebody who knows this thing. Then there are trademarks. Trademarks are essentially, as the name suggests, the marks for trade. So you have company names, logos, etc. Then there are designs, and in the recent patent case you will with Apple and Samsung, a lot of patents are actually design patents. So in India we call them industrial designs or design registrations, but in the US they're called as design patents. But essentially they protect something that is not inventive or new as such, but they're valuable because of the design. And then finally there are copyrights. Copyrights typically protect expressions on artistic work. Things like textbooks or novels, for that matter, movies, music. And in India we even copyright the software code. So that's protect. These are the four major intellectual property rights that protect different kinds of intellectual properties. And I see I have a question here. And just to add a point about trademarks is that if you have a trademark, so let's say you open a company ABC company, and you don't want other people to copy that name, then you should also apply for a trademark for that name. And once you have that then trademark applied for, then you can actually ask those other people to not have the same, keep the same name. And once your trademark is registered, the first stage is applying application, and the second stage is being registered. Once it is registered, you can actually raise a criminal complaint against those people, and such people can actually put to jail. In India, the trademark and copyright offenses are criminal offenses, while a patent offense is a civil offense. Well, and also what happens in trademarks is that there is not, you cannot have an ABC company that is across all kinds of uses. There are 42 classifications in the Indian trademark law, and under each classification you can have the protection. So for example, if there is an Apple company that makes computers, and there's an Apple company that runs trucks, then unless and until the trucks company can be shown to have some advantage based on that, they can very well keep that name. Okay. Company registration information can be found on mca.gov.in. You can just type Google company registration India, and one of the first websites that shows up, government website, you find that from there. Now, let me move forward, and I'll address the question that I've not addressed towards the end of the session, or while we see something relevant. Typically, all the applications, trademark applications take 2 to 3 years. Patent applications take more. Copyrights and registrations, they are instant registrations, so you can get them registered right away. So I told you about what these 4 rights are, and then as we have evolved as a society, as a economy, there have been new forms of intellectual property that were created, and for those forms there are new or more recent forms of intellectual property rights. There's a utility model or a petty patent, which is shorter in time frame and it's not available in all countries. So I'll not go into detail about it, but essentially it is somewhere between a design patent and a regular patent, and that's it right now. Then there are geographical indications and things like champagne, you've heard, or Banarsi silk or Kanjivaram silk. All these trade names have an indication of a geography, and those geographical names now have a value associated with it. So these essentially are like trademarks, but they're granted to a community, they're not granted to an individual. So today, champagne, which is a sparkling wine, is only reserved for the sparkling wines coming out of the Champagne province of France. Everywhere else it has to be called sparkling wine. So that's how geographical indications work. Typically, whenever you go and register any sort of intellectual property, you typically make a check or a search for a similar thing existing before you go and file something or you make an application for something. And there are resources to do that. So, obviously, since this property is intellectual in nature, there's a chance that other people might have come up with something exactly the same or something similar. And for that reason, it's always advisable to search for what already existed. So, because if somebody reached there earlier, then they are entitled to the rights on it and not you. So, let me give you a few examples of what trademarks are. So you can see Coca-Cola and McDonald's and this tiger, if anyone of you has watched Tom and Jerry, will know right away that it has been such a big recognition for a particular brand. On the bottom right, you see a design patent, which basically tries to protect the format or the form of this particular phone. Now, this is, mind you, is not exactly the iPhone. It is an Android device, most likely a Samsung. Recognize one more thing: the intellectual property rights or intellectual property in general intellectual property may be created anywhere, but intellectual property rights, which are legal rights, and because they're legal rights, they're restricted by a law of a country. So, which means that if you want to protect your rights in India, you have to get a patent in India. And if you want to protect your rights in the US also, you have to file a patent in the US as well. Because the laws of each country are different, therefore the patents will be different for each country. There's nothing called an international patent. Even if you've heard that, it's a misnomer or a improperly used term for something that is a convenience feature in patents. So, and I'll keep moving and answering questions side by side. So I was reading from the previous slide of various examples. Now you may ask, okay, these are all international brands, what about India? Well, India has its own things that have happened in the past. Names like Bajaj and Tatas and all are also trademarks, and they are also now looking at innovation. Companies like TCS, companies like Infosys, Cognizant, Wipro are all trying to create intellectual property. The reason for that is that till now we've not been that big a market, but now India is becoming a big market. And as it happens, our main produce apart from agriculture is intellect. We have people here who are smart technically and can generate technology innovations. And other part is that the world as such is saturated. The markets are saturated, and it's India that is a green market. China probably is a green market, so is Brazil. So definitely intellectual property is now gaining prominence slowly but surely. There are impediments also in India, and those impediments are the legal structure. There is always been the thing about patents being enforceable, and that's not only the patents, but any form of law, enforcing that is a very difficult thing. So that's one of the impediments. And the other part is return on investment. That Indian businesses typically have the strong mindset of what is the return on investment. Now, as a rule, every business has return on investment as a very primary marker. However, we have not seen a lot of patents in India, and so we don't understand their relevance. So it looks like an expense. A patent's life is 20 years, and a patent, once you apply it, may take anywhere from 1 year to about 5 years to get granted. So it's a long-term thing, and because it's a long-term thing, a lot of people don't have the patience for it. But as I said in the beginning, in my opening comments, that it may be like a additional cost right now, but very soon it will become a way of doing business. So there is no question that there will not be any return on investment. So with these thoughts, what I've communicated is that it is very relevant in India, and it will continue to become more and more relevant as we go forward. Not only because we are a big market, and so the foreign companies are trying to file patents in India, but also because we are going to generate a lot of innovation going forward. And the question is, should you care? Well, by now I think I have hopefully established that it's not should you care, but the question really is, should you care enough? And it really depends on the kind of business you have. Whether you are doing an e-commerce business, or you're doing a high-tech technology telecommunications device or something like that, or a medical device, or a pharmaceutical drug, you do need to care. And you need to care about several things. Things like your technology, things like your trademarks, things like your artistic expressions or copyrights. You need to absolutely protect those. The problems are, and the reasons for those are mentioned here, that apart from the things that I just said that have direct monetary impact, there are softer things that affect an organization and as a community, the whole country, in a big way. Things are, it reflects the intellectual quotient of the people or the group of people. It creates a high amount of differentiation, which is what is typically looked by the investors. So if you want to woo investors and they know you have patents applied for, then they look at you very differently because they know that you're trying to differentiate yourselves. It increases your valuation significantly, especially if your IP or intellectual property is well crafted. And there is I've seen a lot of junk intellectual property in my career because it was not crafted properly. But if done properly, it is very, very valuable. At the end of the day, it impacts your culture, your organization, or your company's culture as to what you are about. Are you just the other person on the street that has nothing new to offer? You can just try to do the faster, better and cheaper than the next guy, or you have something that's new that you're working on. These are reasons you should absolutely care for IP. And the considerations that are there are unfamiliarity, time, and cost. Usually people are unfamiliar with what IP is, why they should do it, what will happen if they do it well, what will happen if they don't do it well, what kind of troubles can emanate, what kind of benefits they can get, how much time will go into this, and is it worth it? And at the end of it, what about the cost? It is costly, it's not cheap. So is it even for me, a company that's just starting out on my own shoestring savings, should I even worry about this? And the answer to that is that it depends on your case, depends on the kind of technology you're working on. But if intellectual property is the way for you to differentiate, then I don't see that there is any reason you can escape or not do it properly. Because if you do, then sooner or later somebody will come who has deeper pockets, and they will just take over, and you will have no recourse or no defense against such people. So at this point I'll pause a bit and I will take a few questions, and then we'll resume the next phase of my presentation, which is a lot more about what is this unfamiliarity about and why is it so critical. So in the meanwhile, I have, so one by one, patents and I got a question which was, is patent more stringent than copyright? Well, the answer to that is that patents and copyrights protect two fundamentally different things. Patents protect inventions or something that is technically new, there is an advance in that, while copyrights protect expression of an idea. So said differently, the patent may protect an idea itself which is new, but a copyright will only protect its expression. An expression could be that I come up with a new algorithm for faster computing. Now that algorithm can be patented, but let's say I write a code, or I write a code or a book about that algorithm, and those code or those books are actually copyrighted. So that's the difference between the two. So I cannot compare whether one is more stringent than the other. Patents have their own metrics and copyrights have their own. With respect to software, yes, there is no examination that is happening in the copyright. So it's easier to get because you just have to go and file it and they'll give you a copyright registration. With respect to a patent, it will go through an examination and you have to satisfy all the criteria of a patent in order to get one. So that, I hope that answers your question on the patent being more stringent than copyright. Then I also answered the question about patent being filed in different countries. There's a question about, so I'll read the question out. I'm building a new kind of a user interface for a web application. It can be recreated by competitors or other companies once it's out in the market. Can I go for a design patent? Unfortunately, you cannot file, especially for patents or things that are innovative, it is, you lose the right to file for a patent or something like that the moment you make it public. So one of the key things to know is never go public with anything that you think might be an intellectual property till the time you have filed for protection on it. Otherwise you risk being losing all of that intellectual property. So if you have already put it in public, then you can go for a copyright instead of a design patent. And you can also try your luck with the design patent, but I doubt that it will be granted. And that's an answer to Anand Sukumar. The next question I have is from Anuj Chaudhary, which is, when you register a logo for trademark, does it take care of the name of the company also? No, registration of a logo or a trademark is essentially the trademark itself. The name of the company is registered with the registrar of companies, while the trademark is registered with the registrar of trademarks. Now, if you have the trademark on exactly the company name, then you can stop anybody legally. You can stop them from using the same name. As a matter of fact, if you've been around for a while and using a particular company name, and if somebody is trying to take the same name, you can still tell them that, hey, we've been using this name, and they cannot get the same name from the registrar of companies. So I hope that answers your question. The next question is, in India, the IPR is now at the national stage. How much time you see that is fluctuating in India? Well, a lot of factors contribute to this, Santosh, and we've been thinking about it as ourselves because we are professionals in this area. and we think it's very infant right now. We think the level of the level of the infrastructure we have to handle these is also very, very nascent. It is my expectation that in the next 5 to 10 years it will explode in India. We are already seeing sure signs of an interest in IPR in India. So I think it'll in the next 5 years we should start seeing a lot of actions. In fact, I have a marker for it also. The day we have a lawsuit in India where about 100 crores exchange hands in a court battle, immediately everybody will start looking at patents. So I think that may happen tomorrow, or it may take about 2 to 3 years or 5 years. But I don't think it will go beyond 5 years. Immediately after that, it will take off. Now, and as I mentioned earlier, that patents are typically 1 year to 5 year kind of time frame that you get a patent. And you can absolutely, once you applied for a patent, you can then take a product public. And you can put below it the patent applied for. Okay, so I have a few generic questions that I will answer right away. You can, if you have a new application, even using existing products or existing known things, but the application itself is new and it meets the criterion for patents, you can apply for a patent and it will be granted if it is found new. So for any component that you're using in a new manner, you can patent that particular arrangement. And as I mentioned before, that filing a patent and going to market are two very separate things. Nothing stops anybody to go to market without filing a patent. And even if you have filed a patent, you can go to the market. But what I warned or cautioned this group against is, do not make anything that you think is inventive or has an intellectual property public before you have put protection in place. That means before you have filed for a patent, do not make that thing public. Because once you make it public, you lose or you give up your rights to filing a patent on it. And cost of accidental, I mean, in law there is no provision for saying that this was any kind of infringement was accidental. Infringement is an infringement, and it will be dealt with in the same manner. An injunction will be served, and you may need to compensate monetarily as well. Then the deterrence for copyright is essentially the enforcement of copyright is that, as I mentioned, is copyrights are infringement or violations are criminal offense. So if you have a clear copyright, you can serve a notice through your lawyer and ask them to desist. And if it does not happen that way, then you can actually take directives from court and have police help you in stopping any work that the alleged infringer is doing. Calculation of damages for infringement is based on several factors. One is the reasonable revenue lost to somebody, and then any associated losses that can be justified in front of court are taken as a consideration, but there is no formula for calculating damages. Well, e-commerce ideas are per se not patentable in India. In the US they are, because Indian patent law excludes business methods categorically. But there are ways to file e-commerce patents in India. It's a very new line of law. In fact, we are back from a hearing today in the same matter. So I can tell you that it's a very specialized thing to get e-commerce patents. I would say that most of them will not be patentable as such in India, but they're definitely patentable in the US if they're new. And in India also, with some help and some creative crafting, it can be patented. But not all of them though. So we saw that, we were talking about why we should think about intellectual property and what about it in India, how is it relevant, how much it is relevant, what are the constraints. And then we were talking about should you care, and I told you all the reasons. I think the group is pretty well aware of what reasons are. One of the key considerations that stops most people is unfamiliarity. And unfamiliarity is something that will give you a vague idea about the time involved and the cost involved, and that will eventually prevent you from doing anything meaningful about patents. So, and how an familiarity persists is because, to begin with, you need to know what is the relevance to your business about all this intellectual property. What happens in developed countries is every day or every week at least, they will see one or the other case in the news that this patent infringement is getting settled or that copyright infringement is getting settled. Something or the other is happening every day. So they have a very clear idea of what is the relevance to business, and it's a legitimate business cost. But when we don't know that, we are not really clear as to why is it relevant and how is it relevant. And therefore your business strategy does not account for it. Because your business strategy does not account for it, you typically do not spend enough time to figure out a good consultant who can tell you what this is and how it applies to your business. And that's where the cycle starts. If you don't have somebody who can tell you what this is about, then most of the times people lose interest, they lose steam, they may even burn their hands with a couple of consultant attorneys, and then they just end up feeling that this is useless. You spend more money and time than you can ever hope to benefit from, and therefore you determine that it's not worth my time or money. But as I said, that sooner or later we will get into an era where this will become more and more relevant. So the key, according to me, is finding somebody who knows what this is, has done it a lot, and can advise you on everything, including how this fits into your business strategy and what is the relevance to it, to your business. At this point, I'd just like to mention that typically, where these are applied, industrial design patent. Well, I'll just skip these slides because these are meant for some other purpose. But I was talking about the attorney, and in order how to choose your attorney or whosoever your consultant is, you really need to look at their credentials according to the following 6 blocks that you see here. Competency is extremely important. You need to check their technical experience, very important. If they don't have technology experience, they are not going to be useful as patent attorneys. For trademarks and copyrights, you do not need a background, but for patents, you absolutely do. So you must check for those. You must check for the relevance to your technology and the past experience. Cost is everybody's factor, but be reasonable about it. If you if you pay for peanuts, that's what you will get. The other important softer factors are very important, because integrity of a particular consultant in this case is of very high value. You do not want to be in a situation where you're misrepresented, because these things can go public very quickly, and if it is found that you misrepresented something, it will be on record and it will destroy your goodwill everywhere. You must look at your personal comfort levels with anybody who's consulting for you, because that determines how well they can advise you. And at the end of the day, there's no substitute for face time. The more face time you have, the better it is for you. But there has to be a good limit according to that. So look at these factors. Most important is the competency and the relevant experience. Understand that competency, a lot of times it's just not years that determine competency. How you check for competency is how many patents has the attorney drafted, and that is different from just filing. A lot of attorneys in India just file patent applications that are received from outside India, and they're just changing the format and file it to the Indian Patent Office. That does not indicate competency of any level whatsoever. It is an administrative sort of a work and does not tell you that a person can draft a technical patent application. How much prosecution has the attorney done? That means how many patents written by this attorney have been examined, and how many has the attorneys actually gotten allowed, right? So he has to have done on technology grounds, not just on the technical or the legal grounds. It should be somebody who's knowledgeable of technology and can apply technology. It's very important. And very important is that they can actually understand what a technology is, because trust on that if your attorney does not understand your technology, they cannot add any value do it as such, especially in patents. So that's what you do. The next is also keep your expectations realistic about your patent attorneys, because attorneys won't create magic. Magic has to be created by you. They will ensure that your magic gets a maximum armor as well as the maximum amount of artillery so that you can use it to your advantage. And if you're not clear about what you want, what you have, etc., you will be taken for a ride for one reason or another. So you need to be first clear when you're going to an attorney as to what you want done. If you don't know what has to be done, then go and ask them, what should I do? Don't go and say that I want to do something, but then you're unclear and the attorney also keeps going in circles with you. That's not a good way of engaging anybody. Then also know that this is strategic enough for top management. One of the key mistakes I've seen people doing is think, oh, this is not that critical, or this is something I don't want to understand, so let me give it to somebody else, like the head of legal or this guy or that guy. But it has to be driven from the top for Indian companies because this is a new thing, and it is strategic enough for the top management. I'm speaking from 10 years of experience working with the biggest companies in the world to the startups, and not one company is an exception to this rule. Also understand that this is a long-term instrument, so return on investment is not always visible in the short term. There are long-term fallouts, and you need to have the business appetite to do this. In any case, it will be important, but you need to have that appetite all the time. Designing efficient kitchens. You can patent something like a hotel kitchen design and the design features. The question is, can you patent in such a manner that anybody who's trying to copy you will be prevented from doing it? So you will, if you're thinking that patent will take a photograph of the patent, put it, that's not how a patent works. A patent takes the functional features of any device or arrangement and tries to claim that, tries to protect that generic arrangement. So if you have something like that, then it can be protected. The cost typically, so okay, let's quickly answer the cost part. It's usually an important thing for many. There are two costs involved typically when you're looking at filing a patent or any other sort of intellectual property, including a trademark or copyright. One is the government fees or the patent office or a trademark office fees, and the second is the attorney fees or the consultant's fee, professional fee. So typically in India, for individuals, the patent filing fee is 1,000 rupees and the corporate fee is 4,000 rupees. In the US, for a small entity, the filing fees for patent office is $550, and for a big entity, it is $1,100 US dollars. But in terms of the patent attorneys in the US charge somewhere between $7,000 to $10,000 for one application, for drafting one application. That's the professional fee. In India, we charge somewhere around, and that's our fees, or rather the fees that we know, most of the firms that we know in India, they charge range anywhere from 2,000 to like from about 1 lakh to about 2 to 3 lakhs. That's a typical range. There are a lot of other attorneys that are also very cheap. There are also very inexpensive. There are attorneys that have no draft for 30,000 rupees also. So it's a matter of, there's a whole spread of professional fees that is available. You can look out. But in general, you're looking at, in India, if you're looking at an end-to-end filing, just the filing, not the patent grant, you will end up spending from about 50,000 rupees to about 2 lakhs to get a patent drafted, and then less than 10,000 rupees to get it filed on the patent office. Then the next stage is called prosecution, where you respond to the patent office questions, and that is additional expenditure. It will probably cost you about 30,000 on an average for each interaction, and that on an average 2 interactions at least. Cost in the US, as I mentioned earlier, you will look at anywhere from 1 lakh to 3 lakhs of drafting charges. professional fees, and then about 550 or 1100 US dollars for filing, and about 30 to 40,000 rupees on an average per interaction with the patent office after that. So you're looking at, for one patent to get it granted, 2 lakhs is probably the bare minimum that you should expect to spend, and the expenses can go up till 3 or 4 lakhs depending on where you are and which country you're filing. Copyrights are, patents have a term of 20 years from the date of filing, from the first date of filing. Trademarks are long term, they don't have an expiry date. Copyrights have a expiry of 60 years from the death of the creator. So copyrights, for example, any book that was written long time ago, let's say 100 years ago, and the author has been dead more than 60 years, then the copyright is up and everybody can copy. Waiting on trademarks is not a problem. You can wait for later. The only risk you run is that somebody else might file the same trademark and prevent you from filing the trademark. So it's advisable to do it as soon as you can. The cost for trademark and copyrights are significantly lower than patents. Digital educational content. Well, copyright issues in digital educational content, modifying and reselling is difficult. As I said, the copyrights protect the expression, and if somebody can change the expression of an inherent idea, they get around it. The primary way of protecting those things are software tools, agreements that you draft have with people, and the bigger thing is challenge is detecting somebody's doing, somebody's reselling the content without the permission. If you find that, then you can probably find a way to stop them. But the bigger challenge for you will be to find such people. Okay, integrated products are technology patentable, and how much influence does the parent company, suppliers, components have? Well, unless and until you have an agreement of some sort that your suppliers or contractors will own the IP or will not own the IP, you as somebody who's designed, patents cover inventions. Inventions are essentially ideas, and so if you have conceived the idea, then you are the real owner, unless and until you are in agreement with somebody else to give them the invention. So that's the answer to Mr. Swan Kamal Singh Parmar. And also, Mr. Parmar, be aware that if you don't have an agreement also, somebody can raise a contention. Somebody can challenge that, okay, this should have been mine. So it's always advisable that you have agreements with your vendors and your clients that while I'm working for you, anything that I create will be my property. And the same thing with the suppliers, so that you do not get into trouble at a later time. Samples of design patents, you can go to the uspto.gov and search for design patents. You can easily go to Google Patents also, and you can search for design patents as well. Scientific experiment published by the same researcher. Unfortunately, Mr. Badri Narayan, the patent law in India is very, very specific. If you have already published something, unfortunately, you've given up your right. In doing so, you've given up your right to be able to patent. Any patents should be applied for before you make anything public. So, only the US allows a 1-year moratorium. That is, if you have filed something if you have made something public less than 1 year ago, you can still file a patent in the US. But apart from that, Europe, India, China, everywhere, you pretty much give up your rights for patenting. And in general, yes, you can file a patent without the help of a patent attorney. You can do that in India. You can do that in US. And regardless of your nationality. That is, if you are a foreigner, you can still file a patent in India yourself. If you're a foreigner, you can still file a patent in the US yourself. But certain countries like Europe and China do not allow that if you are a foreigner. If you are a resident of that country, you can file a patent yourself. However, if you're a foreigner, you need to engage a patent attorney. However, I strongly recommend that you use somebody who knows the patenting field very well. I have seen countless examples of people completely destroying or devastating the patent application. One thing to understand for patents is that you cannot change the structure after you created it in patents. And since you cannot do that, if you make a mistake at the foundation stage, there is no way you can correct it at a later stage. The only thing you can change is what you are going to get out of it as a right, but you cannot change the structure of it. Mr. Matthew, I will try and answer your question offline. There's a very specific question, and this will go into a lot of details, so we'll probably try to take this offline. Trademark registration costs typically will to file those is about 10,000 rupees in India, and after that you can unless there's some objections or issues, you typically will get the registration over the next 2-3 years. So typical cost of filing a trademark is about 15,000 to 20,000 rupees or less, one class and for one particular mark. One example of a huge lawsuit in India, well, there has not been a huge lawsuit in which compensation has been asked for. There is a Novartis case that's going on, but it's Novartis and the government. TVS versus Bajaj, something else. TVS versus Bajaj is one of the examples in recent times where there was a contention between two companies. And yes, if multiple patents are being filed, that means there are multiple inventions. That means that for multiple patents there will be multiple fees. That's the answer to Mr. Dheeraj. I think I have exhausted all the questions.
Thank you very much, Praveer, for that interesting session. I think all of you have got your answers. Plus, the video recording of all the sessions are uploaded in our website, Eclub at nenglobal.org. And you can also access our videos by subscribing us on YouTube. And thank you to all our attendees for participating in the webinar. We are glad that the questions kept coming. Please do send in your feedback and suggestions to us at eclub@nenglobal.org. Also, if you found the session interesting, feel free to blog or post about it. The recorded version, as I just said, will be uploaded. NEN also has a mentoring session on 1st September from 10 AM to 1 PM at BMS College of Engineering, Bangalore. The mentors are from the field of finance, HR and marketing. Thank you once again and have a nice evening.